For countless families, the journey to America begins with a simple, powerful dream. It is a dream of safety, of opportunity, and of a future where their children can thrive without limits. They imagine a life built on hard work, a life where their kids can go to good schools, pursue their passions, and become part of the American story. This vision is what fuels their immense sacrifices. They leave behind everything they have ever known. Their homes, their communities, their cultures, all for the promise of something better for the next generation. It is a hope so strong it can carry them across oceans and continents, through years of waiting and uncertainty, holding on to that single, bright image of a secure future for their family in the United States. This journey is rarely a straight line. It is a long and winding road filled with paperwork, patience, and persistence. Families diligently follow the rules, paying fees, submitting documents, and waiting in line, often for many years, for their chance to earn permanent residence. They build lives in the meantime, contributing to their local communities, paying taxes, and raising their children as Americans in all but name. These children grow up here. They pledge allegiance to the flag in their classrooms, celebrate the 4th of July with their neighbors, and dream their own American dreams. For them, this country is not a foreign land. It is the only home they have ever truly known and loved. But beneath the surface of this hopeful pursuit, a quiet anxiety often grows. It is a fear that is tied not to their own actions, but to the slow, grinding gears of the immigration system itself. This fear centers on their children. What happens if the process takes too long? For many, the system they entered with trust and optimism can start to feel like a precarious game of chance, where the futures of their children hang in the balance. The stability they have worked so hard to build for their family can feel frighteningly fragile, dependent on bureaucratic timelines they cannot control. This is not just a vague worry, it is a specific and terrifying possibility that has become more pronounced under recent policy shifts. The fear is that a child, after years of waiting patiently with their family, could suddenly lose their place in line simply because they had a birthday. They could age out of their eligibility, not because of any fault of their own, but because the system was too slow to process their family's application. This single administrative detail can transform a dream into a nightmare, threatening to tear a family apart and leave a young person who has known no other home in a state of legal limbo, facing an uncertain and frightening future alone. The green card has long been a symbol of a promise. It represents more than just legal status. It is the key to stability, security, and belonging in the United States. For an immigrant family, obtaining green cards for every member is the ultimate goal, the moment when they can finally breathe a sigh of relief. It means they can put down permanent roots without the constant fear of deportation or separation. It means their children can apply for college financial aid, accept a job offer without complex visa sponsorships, and travel without the risk of being denied re-entry. This promise has always been understood to extend to the entire family unit, especially to the children who are brought to this country by their parents. When parents apply for a green card, their minor children are typically included as dependents on the same application. The expectation is that they will all move through the process as one. This principle of family unity is a cornerstone of American immigration law and values. It recognizes that parents are fundamentally motivated by the desire to provide a safe and prosperous future for their children together as a family. However, recent policy changes enacted during the Trump administration have placed this fundamental promise in jeopardy. These are not small tweaks to the system. They are significant shifts that have introduced new obstacles and heightened old risks, particularly for the children of green card applicants. The changes have created administrative backlogs and altered how applications are processed, making an already slow system even slower and more unpredictable. For families caught in the middle of this process, the rules of the game have seemingly changed overnight. The path to security that once seemed clear, if long, is now filled with new and alarming uncertainties that directly threaten their children's futures. The most immediate danger is the heightened risk of a child aging out. This occurs when a child who was under 21 and eligible when their parents first applied turns 21 before the family's application is finally approved. Under these new, slower timelines, what was once a manageable risk has become a critical threat. A child who has spent their entire adolescence waiting in line with their family can find themselves suddenly disqualified on their 21st birthday. They are no longer considered a child under immigration law and are abruptly removed from their parents' application. their own path to a green card vanishing into thin air, leaving them stranded and at risk of deportation. The journey to a green card is not a simple application. It is a multi-stage marathon that demands precision, patience, and a significant amount of faith in the system. For most families, the process begins when an employer or a family member files a petition on their behalf. This initial step, known as the I-140 for employment-based applicants or the I-130 for family-based ones, is the official starting gun. It establishes the family's place in a very long line. When this petition is filed, the names of the primary applicant, their spouse, and their unmarried children under the age of 21 are all included. At this moment, the family is officially in the system, a single unit moving forward together. Once the initial petition is approved by U.S. Citizenship and Immigration Services, they are assigned a priority date, which is essentially their ticket number in the global waiting line. The U.S. government allocates a limited number of green cards each year, with caps for different categories and countries of origin. For applicants from countries with high demand, like India, China, Mexico, or the Philippines, this waiting period can stretch on for years, sometimes even decades. During this long wait, families must simply hold on, living their lives in a state of temporary status, always keeping an eye on the monthly visa bulletin to track their progress. Throughout this extended waiting period, life goes on. Children grow up, attend school, and may be on temporary visas such as an H-4, which are entirely dependent on their parents' legal status. This makes their situation inherently precarious. The law includes the Child Status Protection Act, or CSP, a complex formula intended to protect children from aging out due to bureaucratic delays. This was meant to be a safety net. However, this protection is not absolute. It provides a buffer, but it cannot stop the clock entirely. A sufficiently long wait can still push a child over the age limit, making this initial stage a nerve-wracking race against time. Consider the story of the Patel family, a fictional but honestly representative example of thousands of real families. Mr. Patel, a highly skilled software engineer from India, came to the United States on an H-1B visa in 2008. His wife and their 6-year-old son, Rohan, joined him. His employer sponsored him for a green card, filing the I-140 petition in 2010. The petition was approved a year later. At that point, Rohan was 8 years old. The Patels had officially entered the green card queue. The years stretched on. Rohan grew from a young boy into a teenager. In late 2022, after a 12-year wait, their priority date finally became current. Rohan was now 20 years old, just months away from his 21st birthday. His CSPA age was calculated to be 19, so he was still eligible. With a surge of relief and urgency, the Patels immediately filed their I-485 applications. They believed they had made it just in time. However, they soon found themselves caught in the storm of the new processing delays. Their application was sent to a field office overwhelmed by the interview backlogs and the last-in, first-out policy. Months passed. Rohan celebrated his 21st birthday not with joy, but with crippling anxiety. A few months later, the devastating news arrived. The USCIS officer reviewing their case determined that because Rohan was now over 21, he had aged out. His I-485 application was denied, his parents' green cards were approved, but he was left behind. After spending nearly his entire life in America, Rohan was suddenly without legal status, facing the prospect of having to leave the only country he had ever known as home, separated from the family that had fought for so long to keep him safe. Beyond the legal technicalities lies a profound and often invisible burden. The constant uncertainty inflicts a heavy emotional toll. Parents live with a persistent low-grade fear that the future they have sacrificed everything for could be ripped away from their child. For the children themselves, the psychological impact is immense. Growing up with the knowledge that a birthday could lead to deportation is a heavy weight for any young person to bear. They are often called documented dreamers. This status can create feelings of isolation and alienation. They feel American, but the system constantly reminds them that they are not. The financial costs are also staggering. Families spend tens of thousands of dollars on legal fees, application costs, and visa renewals. If a child ages out, the costs multiply. This combination of emotional and financial pressure can push a family to its breaking point. The dream of a better life in America becomes a relentless struggle for survival. This is one of the most common questions, and it stems from a fundamental misunderstanding of how the United States immigration system works. The simple and often surprising answer is that for most people, there is no single line to just get into. The system is a complex web of specific, limited pathways. These families are not trying to cut the line, they are in the only lines that exist for them, and they are following the rules precisely as they are written, often for many years. The problem is not their willingness to wait in line. The problem is that the line they were placed in has become dysfunctionally long. They are playing by the rules of a game where the goalposts are constantly being moved. So when people ask why these children can't just get in line, the reality is they have been in line their entire lives. They were placed in line by their parents, who followed the legal process to the letter. To suggest they should find some other line is to ignore the fact that for them, no other line exists. They are not asking for a shortcut, they are asking for the system they put their faith in to work as it was intended. Yes, the Child Status Protection Act, or CSPA, was specifically created by Congress back in 2002 to solve this exact problem. The critical flaw in the law's design is that it only accounts for the time the initial petition was pending. It does not account for the much longer delay that families face while waiting in the visa queue. The safety net is still there, but the fall has become much, much longer. The unprecedented backlogs and administrative slowdowns have overwhelmed its protections. This is why so many children who, by the spirit of the law, should be protected, are still tragically aging out and facing the loss of their future in the United States. The problem is not that the safety net is gone, but that it is no longer strong enough to catch everyone it was meant to save. If a child ages out, can't they just apply on their own? Unfortunately, for a young person who has just aged out, there is almost never an immediate viable path. The grim reality is that for most of these documented dreamers, aging out means their legal status evaporates. They are instantly transformed from a legal dependent to an undocumented individual. The promise made to their parents that the family unit would be protected has been broken, leaving these young adults to face a terrifying and uncertain future alone. What is at stake is more than just the futures of these individual children. When we lose these young people, we lose doctors, engineers, entrepreneurs, and artists who were raised on American soil. This is a self-inflicted wound, a loss for our economy, our communities, and our nation's future. The situation facing these children and their families is not an unsolvable crisis. The immediate challenge requires urgent action to clear the bureaucratic logjams. Beyond immediate administrative repairs, we must also strengthen the existing legal protections. It is time for Congress to update CSPA to more accurately reflect today's lengthy wait times. A simple but powerful reform would be to lock in a child's age on the date their family's initial green card petition is filed. This single change would permanently shield children from aging out due to government delays. This is not a partisan issue. It is a question of fundamental fairness and national interest. Keeping families together and retaining homegrown talent are values that transcend political divides. Ultimately, the choice before us is about what kind of nation we want to be. Do we want to be a country that honors its promises and keeps families together? Or do we want to be a nation where a birthday can lead to a deportation? The answer should be clear. We must reaffirm the principle that America is a place of welcome. By protecting these green card kids, we are not only saving their futures, we are reaffirming the very ideals of fairness, compassion, and opportunity that lie at the heart of the American dream.